Hi, my name is Steve Murphy, and welcome to the Insider Exclusive. Today we have a very special show. It's called America's Finest Trial Lawyers and Southern California's Premier Law Firms, and we're featuring Dan Petrocelli of the law firm of O'Melveny and Myers. Stay tuned. I am pleased to have with us today Dan Petrocelli from O'Melveny and Myers. Welcome to the show.
Nice to meet you, Steve.
You have been involved with some of the biggest cases in recent years, and if our audience doesn't know what they are, what are they?
Well, 10 years ago, I was fortunate enough to represent the family of Fred Goldman in their wrongful death action against O.J. Simpson. And as we all know, that case resulted in a finding by the jury, a unanimous finding, 12-0, that Simpson was responsible for killing Ron Goldman, Fred's son, and Nicole Brown Simpson, the mother of Simpson's two children. The jury returned a verdict in that case of $33.5 million, $25 million of which was for punitive damages.
Really?
That remains one of the largest punitive damage awards ever against a single individual.
And you were also involved in a recent case down in Houston.
Last May, we concluded the trial of Jeffrey Skilling, my client, and the client that an O'Melveny legal team, of which I was privileged to be a part, represented, and Ken Lay, who was represented by Michael Ramsey and other lawyers, in a case brought by the United States government in a criminal matter, alleging that Mr. Skilling and Mr. Lay had violated securities laws. That case resulted in a verdict of guilt against Mr. Lay on all counts, a verdict of guilt against Mr. Skilling on 19 counts, and an acquittal of Mr. Skilling on 9 counts. Now, that case is currently on appeal.
Yes.
Ken Lay, of course, tragically passed away after the trial occurred while he was awaiting sentencing.
Right, that brings up an interesting point, because him passing away before he was sentenced, the verdict was vacated, wasn't it?
Not only was the verdict vacated, but the whole case was vacated. Ab initio, as they say in the law, which means from the very beginning, it's though it never happened. So he passed on with his record legally unblemished.
It's almost like that was the best thing he could do after he got convicted.
Well, some people...
Barring a successful appeal.
Yeah, well, I'm sure he would have preferred to have the ability to withstand that ordeal and see it through to the end, like Mr. Skilling. Now, Mr. Skilling, Steve, was sentenced a few months after the verdict to 24.5 years.
Long time. One
of the longest sentences ever meted out against a white-collar defendant. And here's a man who emblazoned the magazines of the world's most prominent publications just a number of years ago, and being heralded universally as a pioneer and a real leader in business. So it just shows you how the winds of fortune can change. Now, the good news for Mr. Skilling and for all of us who represent him and believe in him is that his appeal is happening right now.
Yes.
In fact, we are getting ready to file our opening brief. And then sometime early next year, we will be in New Orleans before the Fifth Circuit Court of Appeal arguing the case.
Bernie Ebbers, WorldCom, got an equally long sentence. I think it was 25 years. Yesterday, a sentence was handed down on Joseph Naccio, who used to be the CEO of Quest. He only got 6 years. Is the tide changing?
The problem, Steve, is that the federal courts are using a federal set of guidelines, which was really adopted in the 80s by the Reagan administration and Congress at the time for the war against drugs. And it lists out what sentences ought to be in particular circumstances, and the idea was to take away the discretion of judges to determine in their own judgment what a sentence ought to be. So the reason why these sentences are very high and at times may seem unduly low is it uses the guidelines, and you literally go on a chart and you look at what you were convicted for, how much money was involved, and it tells you what the sentence is. It's almost like a vending machine. And of course, we believe that that is the wrong way to sentence an individual. You have to look at a person's life. You have to look at all the circumstances of the conviction, and you have to do what is just. And the sentencing guidelines don't do that.
When you represent anybody, whether it's Jeff Skilling, whether it's, anybody, do you always sit down with them and say, tell me the truth? I want to believe what your side is. Do you say that? I mean, there are lawyers that don't do that, and there are lawyers that do. What kind of lawyer are you?
I think that in the criminal defense arena, there are times when lawyers don't want to ask their clients those questions. That was not the case whatsoever with Jeff Skilling. He understood that this was really going to look like, behave like, and act like a civil securities case, much more than like a criminal case, and he was dead on the money on that. It's probably one of the reasons why he was interested in O'Melveny's civil trial lawyers like myself. But in civil cases, of course, it's very different, Steve, because all the cards are out on the table. So, of course, you get all the information and you get the truth from your client, at least you hope to. And that's one of the beauties of the civil system. I've always advocated that the civil system represents a much more pure search for the truth.
Why is that?
Than the criminal system. Because what the criminal system is about is whether the government can prove its case to such a high degree of certainty that someone's going to take away your liberty and perhaps even your life. Okay? The defendant does not have to testify. So oftentimes, all the facts do not get put out on the table. There's very little discovery, which is the process by which lawyers get all the evidence before the trial. There's a lot of surprises that happen in criminal cases. The civil system is the opposite. The civil system is designed to get all the information, all the facts, bring it to the courtroom. Nobody can refuse to testify. Everybody's got to take the stand. And then a judgment is rendered, and the burden of proof is much more even. So you tend to get to the truth. And I think the O.J. Simpson dual cases are a good example of that.
You found out the truth in the civil case?
We did. And Simpson, the smartest decision that man made in the criminal case was not to take that stand, because he would not have been able to withstand the cross-examination. Now, in the civil system, he didn't have that option. We called him as a witness in our case, and we were the plaintiff, so we went first. And near the end of our case, after we laid out all of the physical evidence and all of the motive evidence, we then called him to the stand and confronted him with that evidence, and I cross-examined him for a couple of days. And had he said to the judge, "Your Honor, I decline to testify," he would have lost by default. So he had no choice but to testify, and of course, he was not able to answer the questions. There was too much evidence that was stacked against him.
Well, this is one of the reasons why I have you here today, and I appreciate you coming here. You're one of the finest trial lawyers in the United States. O'Melveny & Myers is a great law firm, and by the way, the website is www.omm.com.
That's
where you
correct.
can find out more information about you. Thank you very much for being on the show.
Thanks so much,
I'd love
Steve.
to have you back again.
Thank you.
Thank you for watching our shows. I've enjoyed bringing you some great guests. You can see more of them at www.insiderexclusive.com. We'll be back again. Thanks.